everybody. So here, this is the first panel of this research colloquium, and it deals with new technologies, new rights, and legal reasoning. We are going to listen to the presentation of the four doctoral students and PhD students who are participating in this panel. I think the first one is Maria Giulia Servida, who is online. I hope you can hear us. Yes, okay. So she is going to talk about neurotechnologies shaping our brains and legal frameworks. So I leave you the floor, please, Maria Giulia.
Thank you. Dear professors, dear colleagues, good morning. Thank you to the organizers also for allowing me to present from online. Unfortunately, due to health issues, I could not be in person in Milan today, so I'm very sorry to not be able to meet you all in Milan. But still, I will present today on my research, which is, as Professor Salardi explained just a few seconds ago, neurotechnologies shaping our brains and legal frameworks. I have a short presentation. Still, due to health issues, I could not give it beforehand to the organizing committee, so feel free to block me from presenting it. Otherwise, I will share it on the screen. Just let me know, the organizers.
Yeah, you can go ahead and share the presentation.
I will share then. Okay. Sorry for the delay. No, it seems I should go out of the meeting. No? Okay. Okay, yes, you should be able to see the presentation now. So my presentation will be structured the following way. I will briefly give an introduction on neurotechnologies. Then I will move on how legal frameworks should evolve following the development of neurotechnologies. And I will here focus firstly on the debate on neurorights and then on possible alternative paths. What are neurotechnologies? Neurotechnologies are, you can see here a definition given by the OECD. They are devices and procedures used to access, monitor, investigate, assess, manipulate, and/or emulate the structure and function of the neural system of natural persons. So, our brain. Where are they used? They are breaking new ground in respect to understanding and influencing us in our most intimate sphere, so the mind. And they are able to directly interfere with the brain, as we saw by the definition in the previous slide. They were firstly developed for the medical field, allowing and giving life-changing opportunities to people who were resistant to drugs, which help in depression cases or schizophrenia. But soon after, they moved also to the commercial field. So they are used also in a direct sell to consumers, breaking new ground not only in the medical field. They challenge several human rights and several aspects inherently related to human beings, such as self-determination, personal integrity, freedom of thought, and privacy. In fact, by being able to assess what is in our mind. For example, they are able to understand what lies in our mind, and our concept of privacy is challenged. So what should we do in respect to these new technologies? Are the legal frameworks existing at the current moment able to protect us from these technologies, or should they evolve? And this is why my presentation is titled Neurorights, Shaping Our Brains and Legal Frameworks, because in the moment they shape our brains, legal frameworks must follow, and must follow in order to protect this new sphere that is challenged. For what concerns this evolution, different suggestions have been made on how it should take place. Some authors proposed the recognition of new human rights, and I saw the colleague Stocchi will also have a presentation on this a few moments after. And they proposed these new neurorights because they believe that the current legal frameworks are lacking adequate protection. So what is necessary to protect us is not there currently. They proposed more specifically, they proposed the following new human rights: the right to cognitive liberty, to mental privacy, mental integrity, and psychological continuity. These are the rights proposed by Professor Adorno and Professor Jenka. At the same time, Professor Juste and other colleagues of him proposed similar new rights, which also fall under the category of neurorights, and these are the right to identity, agency, mental privacy, and two other rights which are very particular: the right to fair access to mental augmentation and the right to protection from algorithmic bias. Apart from these two last rights, you can see that the others proposed are very similar in their essence, so identity, agency, and mental privacy, to the ones proposed by Jenka and Adorno. But the question is, do we really need these new rights? And several critiques have been made towards this proposal to recognize new rights, and these critiques have been made mainly by legal scholars. And I am saying and emphasizing on the legal scholars part, because the other scholars, mainly Professor Jenka and Professor Juste, are not specialized in the legal field. So they are psychologists, philosophists, and neuroscientists, and they are the ones that brought forward these proposals. So it is very peculiar, the situation, because two persons that are not legal scholars made a proposal in the legal field. And here you may see these four are legal scholars and are the ones that mainly critiqued their proposals, emphasizing how these proposals are grounded on neuro-essentialism, neuro-exceptionalism, and science fictionism. So the idea that they are proposing something, but that this is sort of premature, because many of the scenarios that they want to protect us from are still science fictionary, and that proposing new rights may bring us towards right inflation, so taking away the value of the current rights we have. So what can be an alternative way, an alternative path to recognizing new rights? And it can be the evolutionary interpretation that we, as legal scholars or legal academics, know. And the evolutionary interpretation has already some data from which it can start. So the current situation regarding fundamental rights in Europe and in Italy, I carried out the analysis only in these two legal frameworks, but one could do it also more extended for South America, the United States. Nonetheless, the current situation demonstrates how we already have a framework of rights that are able to protect us and able to give a foundation for a further interpretation of these rights that would be able to protect us also in face of neurotechnologies. So we see right to identity, personal autonomy, self-determination, privacy. These are concepts that are already existing in Europe, in Italy, and that can be the base for a further interpretation, helping, yes, to protect us without changing all the legal system. Alternatives, I will briefly go on this slide because the proposals to recognize new human rights as neurorights have actually been welcomed in South America, more precisely in Chile, where constitutional reform took place it included the concept of neurorights in the constitution. But different paths could be the one taken by Spain, where the Charter of Digital Rights, which is a soft law instrument, has been issued, where in this charter, existing rights have been reinterpreted also in light of new technologies, of new challenges, and this could be a useful path to follow. In Italy, it is interesting to see how a few years ago in 2022, there was a proposal at the Senate made by Senator Cunial to amend the criminal code and completely prohibit the use of neurotechnologies in Italy. And I think you all may grasp how dangerous this could be if such a proposal were carried forward, because neurotechnologies, as I said at the beginning of this presentation, they are actually life-changing in several situations, and they may help people suffering from medical conditions that only through these technologies are able to live a dignitous life, a good life. And by prohibiting completely the use of such neurotechnologies in Italy, this means also prohibiting their use when they are useful for humanity, when they help us take a step forward. So yes, you can grasp the danger in a complete denial of the use. More recently, in May this year, the Senate promoted a second meeting because the first proposal didn't go forward due to the fall of the government. And in May, the Senate held a conference where they manifested the desire to regulate these technologies without completely blocking their use in Italy. What can come next? Still, there is an update on the situation in our country, but the steps could be to take a collective action approach, has been suggested by some scholars, and mainly also Professor Salardi, which is in the room with us today. And my personal idea is that these are new technologies, and going back to the critiques that have been moved by legal scholars and that I showed you before, because of something new that here is neurotechnologies, there is a suggestion that what exists must be forcefully put into the perspective of the new element. And this goes back to the critique of neuroessentialism and neuroexceptionalism. So neuroessentialism, that everything must be reconducted to the neurotechnology, and neuroexceptionalism, that neurotechnologies have something different and really peculiar in respect to what exists up to now, and that justifies a new framework also in the legal field. But I think based on what I've read, on the suggestions, on the critiques made by legal scholars, on the interpretation of current case law, I think that we should put this new element, such as neurotechnologies, under what we already have and the existing perspective of human and fundamental rights, and understand how these current rights may evolve, embracing the new elements as well. So how this new piece of the puzzle can go into the already existing frameworks. And I thank you for your attention. This is a picture of me which more or less gives you an idea of why I'm not there, but also is a picture I've taken because I'm also doing part of my research at the San Paolo hospital, where I see these technologies and how these are being used. And yes, thank you again for the moment that was given to me to present.
Thank you very much, Maria Giulia. I don't know if there are questions from the audience, because otherwise I would organize that everybody presents and then we leave the questions at the end, unless there are pressing issues that want to be discussed right now. Does not seem the case. So the second speaker is Dr. Chen Jie, who is going to talk about legal explanation of judicial behavior and approach integrating the inference to the best explanation and argumentation schemes. So.
Can you hear me, Professor?
Yes, but we don't see you.
Okay, let me
hear you, but we
share
don't
the
see.
screen and open the video. Okay. Can you see me? See my face?
No.
I'm not sure what's wrong with my video. Okay. Let me share the PowerPoint.
If you can try to share your presentation and then. we look at the presentation, perhaps, if it's working, I don't
know. Can you see the slides?
Yeah, the presentation is working. Thank you.
Okay.
So please go ahead.
Okay. Sorry. So first, thank you for invitation. Thank you for inviting me to do this presentation online. And many thanks for my colleagues, Delia Maria Coluccino, send this call in our WhatsApp group of the last JD WhatsApp group. So today I bring a topic about the legal explanation of judicial behavior, an approach integrating the inference to the best explanation, IBE, and argumentation schemes. So first, let me introduce the difference between justification and legal explanation. As we all know, a judicial behavior legal decision making needs to be justified. Reasons must be provided of why certain claims were endorsed, based on what reasons, and it must be specified with such reasons prevailed over the reasons to the contrary. So justifications needs to be critically evaluated to determine whether they succeed in explaining legal decision in a way that is satisfactory for the individuals involved for the society. But explanation involves a third-party perspective which does not presuppose the endorsement of the explained decisions. Davison discussed in a very general philosophical discussion. And about legal explanation, there are two types of legal explanation. One is causal explanation. Causal explanation of legal decisions, which aims at identifying social, ideological, or political factors that contribute to the outcomes of a legal case, including decision makers to adopt such outcomes. So this extra legal and extra systemic explanation of legal decisions can be distinguished from the other one, regional explanations, also called regional reconstructions, by which we may understand the attempt to identify reasons why certain decisions may be legally appropriate, such as given the beliefs, viewpoint, and political, ethical, legal commitments of those who support such decisions. So based on this category, I will introduce two popular theories of legal explanation. One is probability theory. Another is IBE. The first one is the probability theory. When it comes to probability theory, we need to ask what exactly is the proponents of probability theory as the best explanation of judicial proof mean by the word probability? Logic probability or propensity theory or probability as relative frequencies? They could play a role if they were reliable data, but they virtually never are. So another one is the IBE, the inference to the best explanation. But there's some difficulty to apply this theory. So my approach is to combine IBE and argumentation schemes to analyze judicial decision making. So IBE, there is a definition. IBE selects the most plausible explanation from a set of hypotheses based on observed facts. Miquelon describes a classical structure of IBE. I'm not sure if you could see this this structure.
Yes, we can.
Yeah, there's three premises and one conclusion. If there were a principle P1, then there would be a reason to act as required by reason 1, reason 2, blah, 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 reason n. No other principle is better than P1 at providing a reason to act as required by each reason 1, 2, n. If and no other principle is better than P1 at providing a reason to act as required by each reason 1, 2, and n, then there is a reason to act according to P1. Therefore, from 1 to 3, there is a reason to act according to P1, but the difficulty is at premise 3. We can't clearly explain the explanatory relationship of which one is the best, which principle is the best. So I introduced the argumentation schemes to handle this problem. Okay, so what is argumentation schemes? We can easily understand it as structured forms of reasoning that reflect the common patterns in the judicial arguments. For example, there are some typical examples: argument from precedent, argument from authority, the argument from cause to effect, and so on, which have evaluate the strength and the validity of the judge's reasoning. So my refined version is to focus on the premise 3, while the formal IB structure addresses the ambiguity and in the judicial reasoning, clarifying the antecedent consequent relationship, while argumentation schemes insert into the premise 3 to address the interaction of the different alternatives and select which one was the best principle. Multiple explanations such as legal reasoning, personal bias, and political influence, these factors are considered, while argumentation schemes are applied to evaluate each of the explanation and trying to combine it in a formal framework to determine the most aligned with observed decisions. So such approach has some implications for legal practice. IBE accounts for the non-monotonic and amplitative nature of judicial reasoning, while argumentation schemes provide a systematic framework for evaluating judicial arguments. Another is improved judicial accountability. Such a refined version of IBE provide a transparent framework for assessing judicial decisions. Another one is there is a potential for AI system to adopt this approach to analyze judicial data and generate reasoned explanation. So, small summary, IBE and argumentation schemes enhance the understanding of the process of judicial behavior and judicial decision making, and future work also, some of which are in my PhD dissertation is to apply such approach in AI system and explore the factors influencing judicial behavior as more as possible, and combined in unified framework. So, thank you.
Thank you very much for this presentation.
Thank you.
If there are not pressing issues or questions, I would like to go ahead with Dr. Stocchi, who is going to present us a paper entitled Rethinking the Neurorights Approach. So please go ahead.
So thank you. Hello, everyone. My name is Francesco Stocchi, and I did my PhD here at the University of Milano Bicocca in philosophy of law. And today I will present a paper, an oral paper on the question on neurorights. But first, a short premise. We have seen that in recent decades, neuroscience and neurotechnologies have given us unprecedented access to our mental states and our consciousness. Neurotechnologies are nowadays being used in many different fields outside the medical field in which they are born. For instance, we have neurotechnologies application in neuromarketing, forensic neuroscience, biocomputing, and many so-called direct-to-consumer applications, such as entertainment or gaming. Each of these specific fields have shown new ethical and legal issues that need to be assessed and discussed. And within this context, many scholars have proposed new instruments to protect individuals. And in particular, since 2017, many proposals have been discussed both in academic and institutional settings. And the main proposals are today known as neurorights, which are basically new human rights that should help protect individuals from potential abuses and intrusions into the personal mental sphere. There are different positions within this debate, as my colleague was showing before, but the most common one within the neurorights debate seems to be that either there is the need for new human rights, such as cognitive liberty, mental privacy, mental self-determination, or mental integrity, as famously proposed by Jenke and Adorno, or there is a need for an extensive reinterpretation of already existing rights, such as freedom of thought, privacy, or integrity. Although there are good reasons and interesting reasons to discuss the proposed definitions and reinterpretation of these existing rights or introducing new rights, Today, my aim is a bit different, is try to change the perspective on how we approach the discussion on neurorights. The main objective of today's speech is to focus on two pre-existing overarching ethical and legal issues that are often neglected in the debate. The first one would be the relationship between neurotechnologies and power, and the second one would be the absence of a clear societal stance on enhancement. So the first issue is that neurotechnologies can be seen both as instrument of power and instrument for power. In the former sense, neurotechnologies can be used as technology of the self, as technological tool to shape our personal identity and the personal identity of individuals seeking to enhance themselves. And I use the terminology from Foucault, technology of the self, which is used to describe technologies that enable individuals to affect by their own means or with the help of others a certain number of operations in their own bodies, mind, thoughts, and being, so as to transform themselves in order to obtain a certain state of happiness, purity, wisdom, perfection, or immortality. However, differently from the technologies and techniques described and discussed by Foucault, today access, use, and control of these neurotechnologies are often mediated by and controlled almost exclusively by others and not by ourselves, in particular by the technological companies that provide both the hardware and the software. And in the latter sense, as technology for the power, or using the Foucaultian categories again, we could call them technology of the power. These technologies can be employed as a tool by the coercive power of the state, and at the same time as an instrument for new forms of private powers to influence the behaviors of individuals. And within our context, Italian and European context, the constitutional rule of law establishes a specific framework wherein the exercise of public power is constrained by human rights and other mechanisms that are designed specifically to ensure accountability and transparency when we exercise power. However, when we see what these new technologies potentially could be, we see that they have the potential to disrupt the delicate balance between power and various liberties within our constitutional architecture. And at the same time, the same mechanism were not established with the intention or the idea, because it was not conceivable at that time, of counterbalancing these new forms of private power that are more powerful and influential than ever. In contrast to public powers, those private powers are not subject to a clear and specific limitation, and for this reason, this power can lead to new form of abuse and exploitation of individuals in the name of their specific interest that they pursue, given the fact that they are private actors that have their private interest and are not interested in the or just partial interest in the effect on society of certain technologies. So the second overarching issue, which is closely related to the first one, concerns the ethical question of enhancement and its specific issues. Because in order to show this question, we can observe the proposal pertaining neurorights. And in the vast majority of the proposal on neurorights, the principal right that is being discussed nowadays is the right to cognitive liberty, which is defined as a fundamental right that must be acknowledged in order to protect the individual. But the real question is, what is this right and what encompasses? It's not very clear, actually. But in the most common propositions, this right is seen as a bundle of rights that should encompass a number of other rights, such as freedom of thought, the right to self-determination, and most importantly for today's presentation, the right to self-access. to neurotechnologies. And this is particularly in the account of cognitive liberty given by Nita Farahani, for instance. In other words, this right would entail the right to access freely to neurotechnologies or to refuse to do so. And this has a consequence of recognizing a robust legal foundation for enhancing technology, particularly for cognitive enhancing technologies. However, we know that there are different ethical positions within the debate that needs to be discussed when we discuss enhancement. And these ethical positions and the specific ethical issues underlying these positions are usually ignored in the neurorights debate, if not in just some cases. So, on one side of the debate, we have transhumanists that believe that new technologies should be used to ameliorate the human condition, and that effort is both inevitable and inherently positive. So they do not question the use of new technologies, basically. On the other side of the debate, we have the so-called bioconservative position, which holds that human nature should be preserved from technological intervention at all costs. So there are no kind of enhancement that should be allowed. And however, we have a third position, specifically it's very developed and strong within the European context, which holds that the acceptability of enhancement technologies should be determined on a case-by-case basis, taking into account the specific risks and benefit of that particular application. And in addition, they argue also that human rights should serve as a benchmark for assessing the acceptability of enhancing technologies. So in this context, there are some ethical and legal considerations that are frequently overlooked and that need and warrant further examination. For instance, an analysis of the definition of cognitive liberty should investigate the extent to which this right implies other rights and how the legal framework would change. And in addition, the right to access neurotechnology that is entailed within cognitive liberty would entail the right to access new technology for the benefit of the global population while ensuring that access is equitable in order to avoid discrimination. But there are several issues in this case that needs to be discussed. And I will try to discuss the three main ones that I've found. The first one is that the access to these technologies cannot be considered free in the sense that many transhumanists and in general, let's say technological enthusiasts try to depict these technologies because their assumption is based on a fallacy. And basically the assumption is that in a free market, individuals are free to choose what is best for them, what suits their desire and choices. Because they have different options offered them in this market. This free market state, in their view, is the most beneficial for everyone, for all the stakeholders, for the companies because they are free to operate in an unruled market and are able to try to establish a dominant either oligopolistic or monopolistic position, which happens to be the case in many markets of new technologies such as IT technologies in general. And for the individuals, it would be the best scenario because they get to choose between more options because the state of the market would grant a faster technological development resulting in more and better option for the individual. But the fallacy here is that the accessibility of this technology is factually constrained by a multitude of factors that they completely ignore. For instance, the individual's economic status, personal beliefs, religious beliefs, and the knowledge of technology that is needed to give a proper consent to enhancing practices. And all of these factors need to be considered when discussing equitable and fair access to technologies, and transhumanists fail to do so. However, their account of technology is one of the most influential, especially in the context of the big technological companies that develop these technologies. So here lies one big issue. And the second one is the right to access neurotechnology is not the first right that we have seen or discussed within legal scholarship in order to grant access to new technologies. For instance, the right to freely access the internet has been a topic of discussion for almost 3 decades. And even this right, which seems, at least to me, appears less problematic and ethically challenging than granting enhancing technologies to everyone, has not been clearly recognized as a legitimate new human right. And we have just a couple of some recognition at the UN level, but they didn't have real action afterwards. So, and this would be the second problem. And the third one is that the aforementioned technologies have the potential to enhance our cognitive ability on an exponential scale. And here's the problem. It is currently unclear how we could ensure fair access to these technologies, because the most probable outcome, if we think about it, is that the wealthiest section of our society will grant access, will have access to these technologies first, and this will contribute to widen the gap between the wealthiest people on the planet and the less well-off. And many ethical questions are still unanswered. And in my opinion, we need a debate not just between academics or institutions, but involving the whole society, because the human enhancement will have such a great impact that societal debate is needed in this context. Such, for instance, it was proposed recently in a book published by Professor Salardi. And to me, a clear example of all the unanswered ethical question that lies underneath the transhumanist proposals of enhancement can be seen with a simple example. Let's imagine a company that have to choose between an enhanced person and a not enhanced person. So the second one probably is less effective and less productive, and so less valuable to a company. Which one will be chosen? Probably the first one. And will this be considered a form of discrimination? If so, should the state provide for those who can't afford to enhance? This is a very big question. And another question is, and what if they don't want to enhance? Either for personal reason, they are scared of these technologies, they don't trust it, they don't want to be enhanced, or for religious or other moral reasons. How the societal cost of not being competitive in the workplace will be absorbed by our society. These questions are not answered right now and needs to be discussed further, in my opinion. And these are just a fraction of the many ethical questions that we can discuss. For instance, other question could be, which are the cognitive abilities that should be augmented? Who decide that? The private companies that try to build and sell the most profitable products, or should be given the choice or at least we should debate this possibility with the public, with the whole society. So all of these questions, in conclusion, despite a strong consensus on all the potential risks and that neurotechnologies may pose to individuals, and their use as tools by various forms of power, a closer examination of the ethical implication reveals significant ethical challenges that must be addressed before considering the introduction of such rights. Because in my view, as the way we solve these ethical issues will shape and influence the content of the protection given to the individuals. So we need to first debate and discuss and try possibly to solve these ethical issues, and then move on the legal translation of this debate. So thank you.
Thank you very much, Dr. Stocchi. Now we have come to our last speaker of this session, of this panel, who is Delia Maria Coluccino, who is going to talk us about hybrid and collective agency through the digitization of the urban environment, a model to update. That's the question. So please, the floor is yours.
Okay, yes. I'm sharing my presentation, but I see that you can't see it. So just give me a minute to check whether this is possible or not. Okay. Yes, okay. Wonderful. Good morning, everyone. I am very excited to be here. I am Delia Coluccino, and I am delighted to share my current research on hybrid and collective agency through the digitization of the urban environment. I carry out this research under the University of Bologna, and especially under the guide of Professor Antonino Rotolo. So my presentation will follow let's say, three different directives. So first of all, the first part will be devoted to an introduction to the topic and to give a conceptual framework on the main notions I am using and basing my research on. The second one will tackle the problem by adopting both a static and dynamic approach. By static and dynamic, I mean temporally static and temporally dynamic approach, and this notion will be clarified later. The last part will do a recap of my findings so far, and I will give you a brief idea of the next step of my research. So when we talk about a collective agency, we refer to the kind of agency performed by a group of individuals. Not any kind of group of individuals, but those groups of individuals in which agency can't be reduced to the one of the singular agents, singular individuals involved in the group. So it is a kind of agency that builds on individual ones, but is not limited to it. So it is not the sum of the singular individual's agency. Why urban context? Why I'm carrying out my research with specific reference to urban context? Because if you think about a municipal scenario, it is one in which collective agents are typically emerge, typically behave and interact one with the other. Third, of course, digitization is a phenomenon that largely affects the scenario I am describing. So according to the view we endorse, digitization at least doubles the agent by normally providing a digital self to each agent, individual or collective we are considering. I know there is much premises, but I think this is relevant. So I base most of my work on Michael Bratman's notions of collective agency. So Michael Bratman is an American professor who devoted the last 30 years to the study of planning agency and collective agency. And in his last book, edited in 2021, he especially investigated the topic of institutional agency. Now, institutional agency is a kind of collective agency that is typical of groups consisting in medium, large number of individuals. So we're not talking about small-scale activities. We're not talking about small-scale groups, but we are talking about medium, larger ones. Also, what is necessary to, what are the characteristics typical of collective agency, institutional agency, are the ones of related to the structure of the group itself. So the individuals involved normally are distributed among a kernel and a penumbra structure, and I will come back to this notion in a minute. While the third relevant issue is related to their ability to produce, but also to perform on the basis of relevant social rules and social policies, not only related to the mission endorsed by the group, but also with their capacity to make decisions and to establish authority. Now, back for a second to kernel and penumbra. This is extremely relevant also because I have made large use of these notions in my research, at least so far. When we think about the kernel, we should imagine the core part of a group, in this case of this institutional agent. So the one which is joined by those individuals who are most strongly committed with the mission of the group, or at least who show this, so who show attitudes of great commitment. One could think about Hart's internal point of view. And this is something which is endorsed also by Brotman. So he works on the internal point of view notion elaborated by Hart in his concept of law. On the other hand, again, following Hart, the ones participating, so joining the penumbra, are the ones who still comply with the rules, still comply with the policies, but for external reasons. So among external reasons, we could imagine imitation or social pressure reasons. Now, why am I talking about this? Let's reverse the orders that I adopted before. So with regard to digitization, one could think, well, okay, so according to the view you endorse, digitization at least doubles the agents. But the problem is that this doubling is not always a coherent way in which the agent doubles itself. In other words, often what happens is that one side of the agent, either the digital one or the physical one, shows different behavior if considered in relation with its other counterparts. So we could talk about conflicting, ambiguous behavior, and this is something worth of investigate and represented. The second problem I'm trying to tackle is related to let's say holistic way to represent the dynamics between collective but especially institutional agents. So one thing I'm interested to focus on is their internal structure, because yes, we're endorsing a view by which these collective agents, these institutional agents, are more there than the mere sum of the individual agents and agencies, but still something happens inside these groups, and it is relevant to study the internal dynamics of these groups. Something that needs to be considered along this is the dynamics of the interaction between collective agents and the way this interaction can influence also the internal structure of the groups themselves. Why so? Because by adopting this analytic approach, one could shed some light on the issue of hybrid agency, and I will come back to this in my conclusions, but also on the way in which collective agents actually behave, perform, express their agency in urban environments, which is the scenario I adopt. So with regard to the methodology, which is also a preview of my research, the way I decided to carry it out was to establish a toy example, so a hypothetical scenario of interaction between three different groups. And the tools I mainly adopted, by talking about, let's say, literature references, are, again, Michael Brotman's studies on collective agency, Then John Searles worked on speech act theory and illocutionary logic, and I'll come back to this in less than a minute. And finally, Rosaria Conte and Cristiano Castelfranchi's work on cognitive and social action. Now, the final assumption, the final premise. Why did I mention Searle? Just because an important assumption in my research is that I talk about externally perceived attitudes. So I am not referring to internal mental states. I'm referring to the attitudes that can be perceived by an external person, an external agent, more correctly. And we also assume that these attitudes are known or easily. Now, so assessing the problem. Again, I adopted this case scenario in which, on the one hand, their internal structure of each agent was investigated, while on the other, so adopting Michael Bratman's tools, as we will see in a minute. And on the other hand, I also try to imagine a possible interaction between them in the urban context. The static approach was what I called a photography. So an image that one could capture of a urban environment at a specific moment where these three actors exist, either come to existence, either already existing, and interfere one with the other. And the way I called them was city administration, ecologists, and residents. Just imagine them as three different groups of individuals that I tried to describe using Bratman's words and Bratman's notions. Let's just take the case of ecologists. So I also assume that we had groups of 30 individuals in order to respect Bratman's notions of larger scale activity. And I tried to distribute them among a kernel and a penumbra. I also tried to imagine a social rule and social policies for each of them. Just to clarify the difference between a social rule and a social policy, at least according to Michael Bratman, a social policy is a way to institutionalize more, let's say, bottom-up social rule that may exist among the members of the particular group. And I also imagine some procedural rules that they may base their activity and their action on. Now, the second part of my research so far was trying, as I mentioned, to capture the dynamics of the interaction between collective agents. So what I tried to do was also to see how a group, in this case the group of residents, so the third group, could come to existence, so could emerge first from an unformalized way through a small-scale kind of group, and finally to an institutional one, again in Bratman's sense, and how this could also have influenced the activity, the behavior of other groups. Today what I would like to stress is a possible interaction given by this emergence of the residents group with the groups of ecologists. The way I did so, the reason I did so was because this could be particularly relevant if we use some tools studied, adopted, endorsed by Rosaria Conte and Cristiano Castelfranchi, who in the late 90s especially focused on social actions and the way in which a social action in a way could be formalized. So just to give you a couple of examples of what this work is on, Conte and Castelfranchi studied social dependency and social interference as possible relations among agents. And just to give you a couple of information, we have social dependency in a lot of ordinary relations among individuals and among agents in general. So we can describe a relation of social dependency in case we want to pursue a specific goal and we need to perform a specific action to pursue this goal, but we are unable to do it. So we rely on another agent which is able to do so in order to pursue our goal. Again, with regard to social actions, which we also described as behavioral patterns, an important one, a relevant one in my analysis is the one of goal adoption. Again, normally we adopt other people's goal for a number of reasons. And a classic example could be the one that I adopt one of your goals because I expect you to adopt one of mine. Why is this relevant for my research? Because I tried to describe a possible relation between residents and ecologists by way of adopting these tools. So what I tried to do was to describe this interaction as a kind of mutual cooperation. So what I imagined was that ecologists saw the rise of residents as an occasion to better, to more effectively pursue their goals, and so they adopt one of the goals endorsed by residents in exchange for the very same action performed by the other group. I tried to formalize this, and the reason why they do so is to pursue a goal that they both share. So a common goal, also in Bratman's view. Let's come to the conclusion. So what the results so far of my research. So what I tried to prove was that at some conditions, we can describe collective agents operating in the city context, at least some of them, as institutional agents in Bratman's sense. Again, we need a sufficiently strong kernel in order to perform so, but what I would like to stress is that, again, I am basing my work, and I believe that what is mostly relevant is our external perceived attitudes. So, again, participation, the situation of being inside a kernel does not necessarily refer to an internal mental state, so to a genuine commitment. What is really relevant is that a typical attitude, a kind of attitude, is shown, is performed, is perceived by others. And on the other hand, again, the capacity to elaborate and act on social and procedural policies. Again, something that should be stressed, and that also Hart stressed in his concept of law. This doesn't mean that compliance has to be total, has to be complete, but there needs to be a general form of compliance for the group to be called an institutional agent. Secondly, the main aim of my research in this moment was to try and see if these possible dynamics can be described by these patterns of behavior that are normally referred to individual rather than collective agents. And so far, it worked. Now, I would also like to give you some brief ideas on how this could help enhance my further research. So, as I told you before, as I mentioned before, one thing that I'm trying to tackle is the issue of hybrid agency. Why am I calling it hybrid? Again, digitization, according to the view we endorse, at least doubles each agent. But what lacks is a view that does not simply double these agents, so does not consider the physical agent, the digital agent, and the way each of these agents performs and so on, and influence other agents and so on and so forth. What we would like to adopt is a more holistic way to see this. The second problem related to this, of course, is the way we can account for ambiguity. But I do believe that the work on social and cognitive action is relevant also in this sense, because some patterns of behavior, such as imitation or utility-driven action, could also explain a conflicting behavior between two different sides of the agent. Very last thing I would like to stress is that the final reason I am doing so is not only for a descriptive aim. So, of course, I would really like to try to describe a possible model, a normal model of interaction between agents in the urban environment, in municipal environment. But my final aim would be that of building a possible model of interaction where cooperation and participation from below, and so democracy, could be enhanced. I thank you now for your attention, and that's all.
So thank you very much also for this presentation. I would like first to congratulate with the organizing committee for this initiative and also congratulate with the first speakers of the first panel of this research colloquium, because I think they gave us a very broad overview in a very strict time of what the research is on. I have been told that I have some time to do some comments, or that I have been asked to do some comments as discussant here before going to the part concerning the questions that from the audience may arise. The comments I want to do are not concerning each of these presentations, because as you have heard, there is a variety of topics that has been presented, and commenting on each contribution would not be well suited for me and for the research areas in which I am involved. So I have decided to kind of make some general reflections following three keywords that I think are useful to systematize a little bit these all presentations, because these three keywords are present directly or indirectly, or they are assumed indirectly in these presentations. This idea of doing so is because as a legal philosopher we tend to systematize what's going on in reality, so that's what I would like to do. I don't know if I'm successful in that, but in any case I try. So the three keywords I was thinking of that have appeared or have been assumed in these presentations are human behavior, control over behaviors, over human behaviors, and for control I mean ability to make somebody do what one wants, both mentally or physically, and prediction of future behaviors. So these three keywords I think are well suited to a little bit give an idea of how we can put together all these presentations. Before doing that, before going into the details of what these three keywords mean, and so before reflecting on human behavior, its control and prediction, we have to put it into context. And the context is, of course, that of advances in science and technology, but not advances in science and technology that we are living now. It's not just that. We have roots of these advances in science and technology that have become the driver of an increased and detailed focus on human behavior that started some time ago. In particular, in advances in science and technology in different fields at the end of the 19th century. This is well known. And in Italy, there has been, from the legal perspective, the well-known dispute between the positive legal school and the classical legal school that was incentivized by advances in science and technology that put into question how to deal with unlawful behaviors, human behaviors, when new advances were there. These advances that started there accelerated in the 20th century, and another field that was and is very important for focusing on human behavior and getting more information about that, knowledge, explanation, but also the way of influencing and controlling human behavior, is genetics. Genetics that very much developed in the 20th century. And then these advances in science and technology that started in the period I was mentioning before exponentially grew in our current times, in contemporary times. And so we see that from the very beginning of these advances, the focus was on human behavior. The focus was on this aspect. And what is different today with the focus on this human behavior is that in the past, these advances in science and technologies were kind of taking place in different fields, and they were kind of separated. But today, what makes this important and relevance of human behavior at the center of this reflection and attention and description from the new technologies is that they are in different fields, but they have the ability to converge, they have the ability to be integrated, and that is why we are talking about emerging technologies. So emerging technologies have these possibilities. They gave us, they have created the conditions for knowing, explaining, influencing, and manipulating human behavior. This, of course, can be done for different purposes, for ethically justified and justifiable purposes, like in the medical field. The medical field has been mentioned in a different, in at least two of the presentations, but it also can be done for ethically unjustified purposes. And this is due to different reasons. Some of the reasons depend on the characteristics, intrinsic characteristics of modern technologies, which we all know are dual use on the one side, they are pervasive, and they have also this gift of being somewhat ubiquitous, to have ubiquity, which is a gift I would like also to have in my life, but it's not there for now. So these characteristics of these technologies are at the center of ethical concerns because we are always thinking that they can be abused, and in abusing them we can violate, or there is the risk of violating rights, respect for persons, and different aspects of our human coexistence. But there is another aspect which is more important, I think, to be highlighted, is that these current technologies do not have just the ability to be abused and then with the consequences that we can imagine, but they have the power to impact on existing legal categories, on existing ethical categories more in general, and they have the ability to trigger reconsideration of traditional ethical norms, where ethical norms include also legal norms. So that's the transformation. The transformation is important. This transformation, to highlight this transformation, is important because if we think of how human behavior was considered in the past, it was traditionally at the center and was a kind of monopoly of that, of the philosophical, of the ethical, of the legal sphere. These were the spheres that for quite a very long time had the task to guide human behavior, to find ways to guide human behaviors, to build categories, to build norms that had this ability. Today, behavior, human behavior in particular, is at the center of scientific and technological advances that have the powers and the abilities that I have just mentioned, and even more of them. And so human behavior has become part of this reflection and of these studies. And to some extent, it has been taken away from the legal sphere and from the ethical sphere, because they have to be reconsidered, they have to be readjusted to what science and technology is able to do with human behavior. It is not surprising if we think that the notion of human behavior was coined in 1914 by John Watson, and now it's part of the natural language. We use it, but it has still a very important scientific meaning, and that's a meaning that comes out from the last presentation. John Watson coined this notion to be in a kind of dispute about what psychology should be about, to be a science, to be scientific. And the definition of this notion is that for him it was that it is any response of a living organism. Behavior is any response of a living organism to a stimulus which is objectively observed and uniform. So in this sense, we have to distinguish behavior, human behavior, from other notions which do not have this kind of characteristics. Behavior today scientifically means expression of the entire organism. It exclusively consists of observable and describable elements, and it's uniform. That's another important element, because it is the usual and constant reaction of the organism to a given situation. So being uniform is also what makes it object of observation on the one side, object of control, object of prediction, and constructing patterns and gives the ability to construct patterns of behavior. In this sense, we have to distinguish behavior from the notion of action. Action is includes the manifestation of a single principle like will. It has to be distinguished from the concept of conduct that may lack uniformity, and it has to be distinguished from the notion of attitude, which includes anticipatory and normative elements that are not present in the concept of, in the notion of behavior. Why is it important to go back? Because 1914 is more or less the era after which, I mean, there were this discussion between in Italy, as I said, between the penalist and the positivist and the classical school, and the object was behavior, was what could be seen from outside, so what could be observed. Today, this concept of behavior becomes relevant for the new technologies that we have available because it is through AI and the connected technology that we have the ability to extract and use what Shoshana Zuboff, not perchance, calls behavioral surplus. So what comes from the big data flows, and we can use this information, this data and information, related information to predict future behavior and to control behavior in the future. So this is more or less the scenario, and I think that these three keywords were present in more or less all the presentations and more or less explicitly present. So behaviors is at the center of our discussion of what technology wants to do and of what science tries to describe. Now, if we look at this scenario from an ethical lens, we can actually we could do many things. We could try to find out what are the ethical problems related to technical problems. That is not what I'm going to do. This is something that would take too much time. Or we can try to find out what are general ethical problems that are correlated with this focus on human behavior and the consequences that we can predict it, we can control it, not just for sound and ethically justifiable purposes, but also for different purposes that may not be so ethically sustainable. And the three aspects on which I would like to just say a few words, are one has come out very clearly from some of the presentations, is the fact that if human behavior is at the center of technological power and is at the center of scientific interest, those who behave, so humans, should be engaged in this process through what I call, and has been called in literature and is being analyzed as a term that is public engagement. Public engagement has been defined in different ways, but it has at least two levels. The first level is a serious alphabetization, technical alphabetization of citizens, which is the one that is requested by our Code of Digital Administration, for instance, in Italy. But alphabetization and technical alphabetization, which is the prerequisite, the basic prerequisite to make people understand a little bit what's going on around them and how their behavior observed can be abused and used for not ethically sustainable purposes, is just the first level. What we need actually, and this is the aspect which is, I think, still much lacking, is public engagement at the second level. So the level for which we require activities with the potential for two-way interaction between experts and public audiences. That is what we need, and that is what is still lacking. Because this is just this is a way in which we make people participate and are being engaged also in all those projects in which they are more or less explicitly involved, like social projects like urban environment studies, etc. So this inclusion that has to follow this public engagement way is to avoid that there may be forms of surreptitious mass experimentation which are incompatible with the principles of responsible innovation. A second aspect I would like to highlight is that if we look at the scenario that I have very briefly described from through the ethical lens, we have another aspect that we can think of, and that is we are going towards automation, digitization, or digitalization of practically every human activity where human behavior is involved. But the fact is that in some cases, we don't know what are the consequences of these watching the human behavior, exploiting this human behavior, etc. For instance, if we think of children or some experiments that have been done in China with children, etc. in this sense. And so through the ethical lens, we should ask ourselves, this is not my idea, this is the idea, for instance, of Frank Pasquale, that is very well described in his book, New Laws of Robotics, Defending Human Expertise in the Age of AI, that we should pause and think about really what we want to do with these new technologies, with these emerging technologies, if every activity should be involved right now, or if we should pause and think about it, so applying what is the precautionary principle, which is a principle that is not very much loved in general, but which is very, very important, and that is different from the preventative principle. The last point is that if we look at the scenario from the ethical lens, not just in the European context, but also the international level, we see that if behavior and human behavior is at the center, and from behavior we can kind of have many informations about individuals or groups of individuals, etc., then a way of protecting, because this was a problem that came out especially in the first presentation, a way of protecting these individuals is the current human rights framework. Because this is, so technological advances should be put on a human rights footing. We are trying to do that, okay? But this is very important because this can counterbalance things like, or better phenomenon, or better trends like technological determinism, which is very problematic. Why human rights? Because as Peter Kirchschläger has clearly clarified in his book, Digital Transformation and Ethics, human rights make up a minimum standard that enables survival and a life with human dignity. They can enhance a clear setting of priorities based on the minimal standards, and human rights contribute to elaborating the process of agenda setting in technology in terms of sphere of influence and responsibility. Then the question is whether this human rights framework has to be, in some cases, like in the discussion of neurotechnology, be extended, or be extended through new rights, or whether it should, what we have is sufficient, and we have courts have to kind of bring about an extensive evolutionary interpretation. Whatever the answer is to this question, I think that it should be tackled now by those who have expertise in the legal field. That is something that came out also from the first presentation, because at the moment in which we are, at the moment right now, where at the point at which the discussion is, the impression is that there are three basic questions that have not already been clearly answered, and this is problematic for the reasons I will tell you in a while. What are these three propedeutic questions? When we decide to introduce, if we decide that we want new rights, and this has been a problem that has been analyzed in other areas, like in the environmental area, there has been the discussion about introducing new rights some years ago. So if we decide to introduce that, we have to first answer the question, who has an obligation by virtue of the right? And this is not a question that is trivial or superficial, because who bears the primary obligation? At the current moment, it seems that the immediate answer is that state bears the primary obligation for this new right that may be being cognitive liberty, in that sense of being a bundle of rights or being other rights. It's not so, it's important to answer correctly this question, because there are states, okay, the primary obligation to protect human rights, but as those who have the technological power are much richer than states, much important than states today, how do we deal with their obligation in this field? Because the marketing, for instance, of neurotechnologies for enhancing purposes or other purposes that are not medical purposes has already begun, and it's growing exponentially, and it's out of control because there are no specific rules. So the draft recommendation on this topic by UNESCO that are already present on the UNESCO portals try to tackle this aspect and to find some obligations also for companies and tech companies. But Who bears the primary obligation? This is a question that has to be answered. And the second question that has to be answered is what is the scope of that obligation, what we want to do with that obligation, because if we want just rule neurotechnology, well, what neurotechnology? Because it may become old, the one we are talking about, and so law may not be so useful in the future. And how a new right relates to other rights, because in many cases discussions about introducing new rights are discussed as though the rights were in separate compartments. But while we know as legal experts that the framework of human rights and the framework of fundamental rights in Europe in particular is characterized by what Stefano Rodotà called the logic of indivisibility. So when we introduce a new right, what is the impact of this new right to the existing framework? And the answering these questions is fundamental because we have to avoid the two main problems in a legal system. First, or in a normative system in general. The first one is indeterminacy, and the second one is inconsistency. If we have these two big problems in a legal framework that should guide everything else, then that legal framework is not going to be useful at all. So these are more or less my general considerations on the topics that have been presented. Hope they have been somewhat useful. I would like to open the discussion now and see whether there are questions from the audience or from also from people at home on the different topics. So we have 5 minutes, 10 minutes, okay. Nobody dares, or you would, yeah?
I have a question for Delia. When you were discussing the fact that we have like a dissonance between ourself and our digital self, I was wondering if you were also referring at the phenomenon that we can observe in or on the internet, on social platforms, for instance, like the abuse of hate speech in online communication, whereas people normally in the same people normally in normal context, in real life context, do not talk in the same way, do not express in the same way. Thanks.
Thank you, Francesco, for a very nice question. Actually, this is one of the issues that I want to tackle because it is quite evident that for many individuals, when they act online, so when they act, let's say, through their digital self, they promise also things that not in real life, but in physical life, they would not be available to do. So this may be one kind of what I described, conflicting behavior. So, but more than conflicting behavior is a sort of conflicting agency. Because on the one hand, you normally perform on a physical side in a way, but your digital agent says a different thing. And if we could transpose your digital self into a physical self, it would be a very different one from the one that it is actually operating. So thank you for the clarification.
Are there other questions, curiosities? Please, Marta, can you speak at the microphone? Okay.
Thank you. I'm Carla Gulotta. I teach international law here at University Milano Bicocca. I want to congratulate on your presentations. I'm not an expert of all the topics you have dealt with, but I've studied the topics dealt by the first and the third speaker, and I really congratulate them for their ability to express quite clearly and completely the state of the art, and adding something that will allow the jump to more knowledge. So I found your work really useful. I hope you will publish the written papers. And I have one question or consideration or thought to share with you. I think that both the first and the third speaker, but also all the research by Delia Coluccino, sorry, I was thinking Diana, I couldn't remember the name, deal with how to engage society. We understand also through the research of Prof.ssa Salardi how at this stage it is important to engage society, to have a decision, not to leave the decision on how to deal with these new technologies to regulators, legislators, politicians, but to understand what our society wants to become, how wants to go on, be regulated, deal and interact with these technologies. But my fear is that this society is not ready to express a well-thought and well-informed position. So I think that what we will have to, the next challenge, the first challenge will be to ask ourselves how this problem can be faced. Thank you.
Yeah, that's true. That's the major problem, the propedeutic problem to be solved. Are there other questions or considerations? Francesca Gasparini from the Department of Informatics.
Yes, thank you very much for your presentation. They were very interesting. I just want to put in evidence that what scares me maybe more is that new technologies as well as AI in general will probably increase the gap between poor and rich people. This is something that you have introduced in your presentation. So I think that this is one of the points where we have to work a lot, especially from our point of view also, computer scientist point of view. So thank you.
And if I may just add one thing on this, is that there is this idea of widening, the risk of widening the gap that we were discussing, and I totally agree, of course. And I think also there is another aspect that is, we cannot, pass me the term, dump these new technologies on top of everyone. Because, for instance, there is this case, I know it's very easy to talk about Elon Musk, but here it is. Elon Musk decided to give internet to this tribe in the middle of somewhere, I don't remember where, but they do not had any kind of instrument to actually understand how to responsibly use these technologies, and basically the whole society, small society, collapsed in a couple of months. So everyone was just using internet because it was so new and so impactful and so different from what they were used to, that all their social interaction basically stopped. So I think there also this question on how we can make sure that people responsibly start using these technologies, and what is our responsibility as researcher, as expert in this field, to communicate, to have, like in Italy we say terza missione, like to explain and have a meaningful connection with everyone that may be affected with these technologies. So there is another interesting question. Thanks.
I can also add, did you want to add something? Also, in relation to what Professor just mentioned, I just wanted to say that in Bologna, the project of the digital twin of the city is being developed, and I am part of the so-called ethical team So we are preparing the ethical framework for the ones that we have to develop the actual problem. And something that we are very, very much discussing also with the legal group, the legal team, is that of how to make informed consent, how to engage people. But this can be, in my opinion, can be assessed from a very superficial point of view if we just consider a lot of paperwork, a lot of questions to do the work. So what we are focusing on, at least what we are trying to draw the attention on, is also considering that we're not of the same age. So we also, our literature and our literacy, our digital literacy differs a lot if we consider different generation of people. And so I do think that this is something that has to be taken into consideration also to, if not reduce, at least tackle the digital divide, not only between the poor and the richer, but also among different generations. So to consider that the level of literacy is different, and we have to take this in mind while designing legal tools and digital tools.
Yes, thank you. So if I may add, the informed consent procedure is not enough for what we are talking about. I mean, that's just a way of filling the gap in some specific situation, but the public engagement is something that has to be brought about by institutions at different levels. So that's informed consent may be used in specific situations, but it's not solving the problems. So we are not solving the problems with this instrument. So thank you very much. If there are not further consideration, people at home, I don't know if Chen or Maria Giulia Servida wants to add something.
No, I'm good, and I thank also the considerations by the professors in the audience.
Okay. Thank you very much then for attending this first panel. It will go on. There is a coffee break right now. Okay, there is a coffee break, and then it will go on with an Italian panel. So have a nice day. Thank you very much.
Thank you.
Thank you. Have a nice day.
Piccola nota organizzativa, abbiamo appunto un coffee break qui fuori per una pausa di all'incirca 30 minuti, dopodiché dovremo iniziare per finire, diciamo, in tempo